As a pure matter of law, this is in fact a merely procedural decision, yet it is going to be one of the most substantive decisions in a long time. Viva Frei, Montreal litigator turned YouTuber, and it's been something of a bad week to some extent for big tech. Google is getting sued by Rumble, Amazon is getting sued by Parler, and now this unfavorable decision to Twitter coming out of Canada. A lot of my Canadian following asked me to do more Canadian content, but to me, American law, American legal issues is sort of like the forbidden fruit. I grew up and studied Canadian law. I am more entranced by things that I know less about. That, and typically Canadian law is just more boring in substance and in form. I mean, just look at this decision on paper. This decision is boring to read. Long paragraphs, the layout on HTML is boring compared to those beautiful PDFs coming out of the Supreme Court of the United States, but regardless, let's get into this decision. Now, when I say that this is a purely procedural decision, it's because it relates only to the jurisdiction. There is no determination on the merits. There is no final judgment. This is merely a judgment on jurisdiction of where the lawsuit can be heard. That being said, this could be one of the most substantively damaging lawsuits to Twitter's interest in that it now allows for Twitter to be sued for defamation outside of the United States in other jurisdictions. All right, I might be getting ahead of myself here, but as I just mentioned, this lawsuit is based on defamation. But it's not a lawsuit based on defamation accusing the defendant of having uttered the defamatory words. It is a lawsuit in defamation against the defendant, Twitter, for having hosted the defamatory words. For having hosted and failed to respond to the allegedly defamatory tweets that were found on Twitter. All right, with that said, let's just jump into the decision itself because the introductory paragraphs actually set out the fact pattern better than I just did. In the Supreme Court of British Columbia, Justra versus Twitter Inc. 2021 BCSC 54. Before the Honorable Mr. Justice Myers. Reasons for judgment, jurisdictional challenge. Introduction. Tweets span international boundaries, making for jurisdictional issues with respect to the adjudication of legal claims relating to them. Mr. Justra has brought this lawsuit against Twitter claiming damages and an injunction for defamatory tweets authored by others and relayed on Twitter's internet platform. Justra has strong connections to both British Columbia and California. Twitter is based in California, the tweets were read in Canada and the United States and no doubt elsewhere. Does this court have jurisdiction to hear the claim? Twitter says it does not, and if jurisdiction exists, I should decline to exercise it because California is a more convenient forum, the doctrine of forum convenience. This judgment is concerned with that issue only. It does not deal with the merits of the claim. As we can see from the introductory paragraph, the lawsuit itself on the merits is seeking damages and an injunction, and we're not going to go over the criteria of obtaining an injunction again, but that is what the lawsuit on the merits is about. This judgment, however, is only on the question of whether or not the court has jurisdiction to hear the claim on the merits. Twitter is arguing that the British Columbia court does not have jurisdiction to hear the case, and that even if it were to determine that it does have jurisdiction, it should decline jurisdiction nonetheless on the basis of what is known as forum non-convenience or forum convenience, meaning that there is a more appropriate forum for the lawsuit than the British Columbia courts. And Twitter argues that the more appropriate forum for this lawsuit to be heard is in fact the courts of California for obvious reasons that we're going to get into now. And for those of you who may be interested in the nature of the allegedly defamatory tweets, I'm going to post a screenshot of the paragraph describing them. Suffice to say that they relate to Bill Clinton and a number of other issues related to Bill Clinton. We don't need to go over that for the purposes of this vlog. The tweets were allegedly defamatory, and they were allegedly defamatory because they made rather serious accusations of very wrongful conduct specific to the individual plaintiff. The tort of defamation protects reputations. Mr. Justra has a substantial profile and reputation in both Canada and the United States. This case illustrates the jurisdictional difficulties with internet defamation where the publication of the defamatory comments takes place in multiple countries where the plaintiff has a reputation to protect. The presumption is that a defendant should be sued in only one jurisdiction for an alleged wrong, but that is not a simple goal to achieve fairly for internet defamation. The court then describes the obvious and darn good reason for which Twitter would want this entire venue shifted to California, namely that in California, the plaintiff would not have a cause of action because of U.S. law. One of the significant factors in this case is that both parties acknowledge that under the law of the United States, Twitter would have no liability to Mr. Justra pursuant to the freedom of speech protection in the First Amendment to the United States Constitution and two other statutes. No such statutory protections exist in Canada. Whether the Canadian common law provides or should provide similar protection to a platform such as Twitter would be a matter for an ultimate trial and was not argued in this application. Twitter obviously wants the venue shifted to the courts of California because under United States law, the speech at issue would probably be protected under the First Amendment of the Constitution, freedom of speech, and Twitter in any event would benefit from immunity under Section 230 of the CDA, the Communications Decency Act. So Twitter wants the venue shifted to a jurisdiction in which it would have no liability, whereas it might in fact have liability on the merits in a Canadian jurisdiction. And how does the court deal with Twitter's request for a change of venue on the basis of forum non-convenience? well, it rejects the claim, and it does it for very interesting reasons that are going to have serious repercussions for Twitter. The judgment then goes on to describe Mr. Justra, his character, that he has a reputation to protect in a number of jurisdictions, including Canada and more specifically British Columbia, where he conducts business. Then the judgment goes over the tweets at issue. Suffice to say, they are relatively shocking tweets. Whether or not you have lived on the internet for long enough, they may be more or less shocking to you, but they are allegedly defamatory, and that is all that matters for the time being, because we are not getting into the substance of the lawsuit as to whether or not they are in fact defamatory. Right now, it is a question of jurisdiction and jurisdiction only. The Court Jurisdiction and Proceedings Transfer Act, SBC 2003, sets out the framework for court jurisdiction. The legislation adopted model legislation proposed by the Uniform Law Conference of Canada. It was meant to codify the common law. Section 3 sets out the circumstances when a court has territorial competence, jurisdiction simpliciter, over a person. A court has territorial competence in a proceeding that is brought against a person only if e. there is a real and substantial connection between British Columbia and the facts on which the proceeding against that person is based. Section 10 sets out presumptive factors establishing a real and substantial connection. Mr. Justra argues that 3 are relevant to the arguments in this case, without limiting the right of the plaintiff to prove other circumstances that constitute a real and substantial connection between British Columbia and the facts on which a proceeding is based. A real and substantial connection between British Columbia and those facts is presumed to exist if the proceeding G. concerns a tort committed in British Columbia. H. concerns a business carried on in British Columbia. I. is a claim for an injunction ordering a party to do or refrain from doing anything, 1. in British Columbia, or 2. in relation to property in British Columbia that is immovable or movable property. In its analysis on whether or not the court has territorial competence, the court comes to the conclusion that when it comes to defamation, it does in fact have territorial competence, and in so coming to that conclusion, it relies on precedent known as Haaretz versus Goldhar. That was a sufficiently similar decision where the newspaper called Haaretz, which is based in Israel, had published something that was allegedly defamatory. They published it in print in Israel, but electronically also in Canada. And because according to the evidence, the digital publication in Canada did in fact reach 200 to 300 people, the Canadian courts determined that they had jurisdiction to hear the claim on defamation. I will deal first with the presumed connecting factor of a tort committed in the province. The governing authority regarding jurisdiction over internet defamation cases is the Supreme Court of Canada's decision in Haaretz.com versus Goldhar, 2018. At paragraph 36, the majority reiterated that the tort of internet defamation takes place where the defamatory statements are read, accessed, or downloaded by a third party. Mr. Justra's unchallenged allegation that the defamatory statements were read by persons in BC is therefore sufficient to establish the presumption of jurisdiction simpliciter. It is then up to Twitter to rebut the presumption.
Would you like to present your rebuttal?
With pleasure.
Has Twitter rebutted the presumption?
Spoiler alert, no, they haven't. What, if anything, distinguishes the case at bar from Haaretz for the purposes of jurisdiction simpliciter? At root, the principal factor relied on by Twitter is that it is a platform which posts messages created by others. It cannot therefore be expected to defend actions in any jurisdiction in which an allegedly defamed person has a reputation and in which the offending tweet has been accessed. Translation, Twitter's argument is effectively that you do not have jurisdiction, Canadian courts, because on the merits, Twitter cannot be held liable. Twitter was not the one making those statements, they were merely the platform hosting those statements on which those statements could be found. Therefore, they cannot be held liable. Therefore, the Canadian courts do not have jurisdiction. What does the court say about this relatively circular logic? That is a somewhat circular argument because it depends in part on the substantive law that might be applied, namely whether an unmediated platform such as Twitter is legally responsible for content posted or tweeted by others. That is not a settled point in Canadian law, and the point was not argued in this hearing. The bottom line, and it's a huge bottom line, is that the Canadian judge is basically saying it's not clear under Canadian law that Twitter cannot be held liable for defamation for merely hosting defamatory tweets. It may very well be settled law in the United States. It may be settled law in other jurisdictions, but it is not settled law in Canada, and it can therefore not serve as the basis for the courts denying jurisdiction because it is, in any event, a question of the merits of the dispute. It is not a reason for the courts to deny jurisdiction to hear the case, and in any event, it is a question on the merits that is going to be answered on the merits, and it leaves open the possibility that Twitter can in fact be held liable under Canadian law for defamation as a result of tweets hosted on Twitter's platform. And that precedent alone should be very, very, very scary for Twitter. The argument then turns to whether or not there is a more appropriate forum than the courts of British Columbia to hear the case. The CJPTA sets out the framework for the forum nonconvenience analysis. Discretion as to the exercise of territorial competence. After considering the interests of the parties to a proceeding and the ends of justice, a court may decline to exercise its territorial competence in the proceeding on the ground that a court of another state is a more appropriate forum in which to hear the proceeding. A court in deciding the question of whether it or a court outside British Columbia is the more appropriate forum in which to hear a proceeding must consider the circumstances relevant to the proceeding, including A. the comparative convenience and expense for the parties to the proceeding and for their witnesses in litigating in the court or in any alternative forum. B. the law to be applied to issues in the proceeding. C. the desirability of avoiding multiplicity of legal proceedings. D. the desirability of avoiding conflicting decisions in different courts. E. the enforcement of an eventual judgment. And F. the fair and efficient working of the Canadian legal system as a whole. Reading those criteria, you don't have to be a lawyer. Heck, you don't even have to have stayed in a Holiday Inn to know exactly where the court's going to go and exactly why the court is going to go there. With respect to the witnesses alone, it is obvious that all of the witnesses are going to be located in British Columbia because that is where the allegedly defamatory statements were read. Twitter tries to argue that the documents at issue are going to be found in California, therefore the courts of California are going to be the more appropriate forum, and the judge does not retain that argument. Twitter argues that all of its documents will be in California. I place little or no weight on that. It is apparent from the evidence and the nature of the case that the bulk of the evidence will all be in native electronic format. Moreover, the location of the documents can no longer be considered a significant factor given that even if they were in paper format, they could be scanned. And one cannot be a judge for any length of time and not observe that lawyers frequently have paper documents scanned for their own purposes. Trials here are frequently conducted with documents in electronic form only, and particularly so during the COVID crisis. The location of documents may have been a potential major concern when the CJPTA was drafted, but that is no longer the case. This was a pretty bad argument for Twitter to have raised, and like I've said in previous vlogs, if you have good arguments and bad arguments, don't raise all of them, because by raising the bad arguments, you actually only discredit your good arguments. It is quite clear from the judge's tone here that Twitter just did some damage to their credibility in front of the judge. Twitter then tries to argue that the tweets themselves were American-centric, therefore the American courts are the better forum to hear the case. Twitter says that the tweet's contents are American-centric. It points to the allegation in the amended notice of civil claim that I quoted above at paragraph 25 regarding the Mr. Justra's involvement in the US election being the impetus for the tweets. However, as Justra points out, while his charitable and philanthropic work in support of the Clinton Foundation was the impotence of the libel against him published by Twitter, the notice of civil claim itemizes tweets that are Canadian-specific, and you can read them. In furtherance of its argument for change of jurisdiction on the basis of forum non-convenience or on the basis that the California courts would be more appropriate, Twitter tries to argue that any judgment it might get against it in Canada would be unenforceable in the United States. Because of the laws in the United States, even if there were a negative judgment rendered against it in Canada, it would be unenforceable in the United States given the Section 230 immunity and First Amendment rights. I'm not sure if this is actually true on the merits. Nonetheless, they raise the argument and the judge dismisses the argument. Enforceability. Twitter points out that Twitter has no assets here and says that a monetary judgment would have to be enforced against it in California, where a judgment for defamation would not be recognized. Nor would a California court enforce an injunction order, and because Twitter has no presence in British Columbia, there is no way to enforce an injunction application against it here. It argues that this is a factor in favor of declining jurisdiction. Twitter argues that the inability to enforce the judgment makes this proceeding, quote, largely pointless, end quote. So pointless that Twitter is fighting tooth and nail to have the jurisdiction changed to the California courts where it knows it will win because it risks losing in Canada.
Largely pointless?
You keep using the word. I don't think it means what you think it means.
Two things underlie the concern about enforceability. The first is the consideration of comity, namely should a court grant a judgment which a foreign court will not enforce because a judgment under our laws offends the foreign jurisdiction's laws. I will deal with this issue of comity later. The second concern is the possibility of multiple proceedings if the defendant has no assets here, therefore necessitating the plaintiff launching enforcement proceedings in another jurisdiction. Here there appears to be no possibility of a multiplicity of proceedings because there would be no point in trying to enforce the judgment in California. Further, and nothing I have concluded hinges on this, Twitter has not deposed to the situs of the shares of its Canadian subsidiary. That may be an asset in Canada that can be executed against. The court then addresses the argument on applicable law, which Twitter obviously wants to argue to have the jurisdiction changed because under United States law, Twitter will be immune from the accusations of this lawsuit, whereas in Canada, that's not necessarily the case. I begin by noting that this court has held that a defendant who raises a forum convenience challenge must point to another alternative forum and cannot simply rely on an argument that British Columbia is an inappropriate forum. Second, and more apt to the current case, a defendant challenging the forum must establish that there is a clearly more appropriate forum. This was repeated frequently by Justice Sopinka in Amchem Products Inc. versus British Columbia Workers' Compensation Board. In fact, Justice Sopinka at paragraph 26 recognized, albeit more in the context of anti-suit injunctions, that there might be cases where there is no clearly more appropriate forum, and at paragraph 29, that the consequence might be parallel proceedings. And then the court puts it beautifully and succinctly as follows. The simple and obvious point here is that California cannot be an alternative form at all, much less the clearly more appropriate form, when the plaintiff would have no cause of action there for tweets published in British Columbia and harm suffered in BC, to which BC law would apply under our conflict rules. Here the judge actually geniusly flips Twitter's own argument on its head to hurt Twitter. Twitter is saying that the courts of California would be the more appropriate form because under California law the plaintiff would have no rights. To which the judge wisely responds, why on earth then would California be the more appropriate courts for the plaintiff when they would deny the plaintiff any rights whatsoever? The California courts would deny plaintiff any remedy for tweets that were published in British Columbia, read in British Columbia, and for a damage that occurred in British Columbia. Congratulations, Twitter, you just made the best argument for why the courts in British Columbia should hear the case.
Congratulations, you played yourself.
And just to conclude, the judge writes as follows. Balancing all the factors, I do not think this court ought to decline jurisdiction. So that is the judgment. We will see if it goes to appeal, and although it is only a procedural judgment on whether or not the court has jurisdiction, it is a very, very serious judgment, not just for Twitter, but also for the likes of YouTube. We don't know what the outcome of this is going to be on the merits, whether or not Twitter will be held liable for defamation as a result of tweets that were left up on the platform that Twitter did nothing about, but this opens the floodgate for lawsuits of defamation against Twitter and against YouTube. And there is no Section 230 immunity in Canada, so this opens up some serious liability for the likes of Twitter and YouTube. I will obviously be following up as there are any updates, doing vlogs on any further decisions and on the judgment on the merits if and when we ever get one. But with that said, if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, subscribe to our YouTube membership. Robert Barnes and I have a page on Locals. It is called vivabarneslaw.locals.com. All members and supporters get sneak peeks of my vlogs in as much as possible. I am also on Rumble, where you can find all of my YouTube content for those of you who want to get away from YouTube. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.